All right. Hi, everyone. Thanks for joining us for this webinar, Driving Investment in Wind Energy, the Role of Incentives in the Inflation Reduction Act, hosted by the National Renewable Energy Laboratory and the U.S. Department of Energy's Wind Exchange Initiative. We have some great speakers and insights to share with you today, so I'm going to get right into the webinar logistics. So this webinar will be recorded and posted to the National Renewable Energy Lab, or NREL's YouTube channel. The link is right there, but you can also find it pretty easily by searching on YouTube. And the US Department of Energy's Wind Exchange website, link is also right there. You'll also receive a recording of the webinar and the slides and a Q&A document in your inbox in about a month. You can pose questions using the Q&A function during the presentations and also at the end. Questions will be answered either during the webinar in writing, or I will pose them to our speakers at the end, or you will receive a written Q&A doc to your email, like I said, that will have answers to your questions in case we don't get to them. So in this webinar, we're going to cover the history and impact of major tax credits and incentives. We'll also cover an introduction to the Inflation Reduction Act, or the IRA, and its role in the industry, and then we'll have some time for Q&A. I'll now just quickly introduce our speakers. Brian Lips is a Senior Energy Policy Project Manager for the North Carolina Clean Energy Technology Center. He manages the database of state incentives for renewables and efficiency, or DESIRE. In addition to coordinating and overseeing the project's administration and research, he also authors DESIRE's content for California, Hawaii, North Carolina, Nevada, and South Carolina. He joined the center in 2006 and became the manager of the DESIRE project in 2013. He has a degree in integrated science and technology from James Madison University with a focus in energy and environmental science. And then Bryn McDowell is a researcher on the human dimensions of wind energy team at NREL. She specializes in workforce and economic development for land-based and offshore wind. Her work supports the wind workforce team through workforce assessments and modeling, stakeholder engagement activities, and policy analysis. She holds a master's degree in renewable and sustainable energy from the University of Colorado Boulder and a bachelor's degree in chemistry from the University of Illinois Urbana-Champaign. And now I will hand it off to Brian, who will start with our history and impact of major tax credits and incentives introduction.
All right. Thanks for that intro and for the opportunity to present today. Next slide, please. So my organization, the North Carolina Clean Energy Technology Center at NC State University, is home to the Database of State Incentives for Renewables and Efficiency, or DESIRE for short. DESIRE is the most comprehensive public source of information on all the federal, state, and utility administered financial incentives and regulatory policies that support the use of renewable energy, energy efficiency, energy storage, and electric vehicle technologies across all 50 states and the territories. All told, DESIRE has detailed summaries of about 2,500 different policies and incentives. So you can see our URL there. On the homepage, which is pictured here, you can enter your zip code into the search bar or click on your state on the map to see a list of all the policies and incentives available in your area. And then from there, you can apply different filters to see just, say, rebate programs for residential heat pumps, or loan programs for energy efficient windows, or tax credits for solar and wind, which we'll be talking about today. So I encourage everyone to visit DESIRE after this webinar and put it to good use. Now, DESIRE is focused on policies and incentives that support the use of renewable energy. You can stay on that other slide. Yep. But that doesn't mean there aren't incentives for other more traditional forms of energy. In fact, you'd be hard-pressed to find a sector of the U.S. economy that's been more incentivized throughout our history than energy. I didn't come up with this chart myself, and you can find similar figures elsewhere. And whatever the actual numbers are for the total subsidies received by fossil fuels depends on where you decide to draw the box around federal activity. But I think this does a good job of pointing out the general extent of federal support for energy over time. And I don't mean to, critique these other technologies or say that this is wasted money. Energy is the lifeblood of modern society, and it makes good sense for the government to ensure its supply. But I do think it's helpful to be aware of the amount of money the federal government has dedicated to fossil fuel industries, because the support they've received from the federal government over time can be a little bit shrouded, a little obscured when compared to the tax credits for wind that I'll be discussing in a minute. Those tax credits, the ones for wind, have their own sections in the tax code, and everything is very clearly spelled out and straightforward, at least to the extent that the federal tax code can be straightforward. But it's easy enough for an opponent of wind or solar to point to these specific sections of the tax code and put a target on them. Not so easy with the incentives enjoyed by the fossil fuel industries. One of the biggest incentives enjoyed by the coal industry, for example, is the federal government allowing owners of coal mining rights to reclassify income traditionally subject to income tax as royalty payments instead, which are subject to capital gains tax, which historically have been much lower than income tax rates, particularly the very high marginal tax rates that existed throughout the mid-20th century. Oil and gas, for their part, were given their own special tax treatment with the ability to fully depreciate intangible drilling costs, as well as costs associated with drilling a dry hole, entirely within the first year, rather than being fully capitalized and depreciated over time. And this doesn't even include the special ways that the federal government has enabled the transportation of fossil fuels. Coal wouldn't be very helpful without the trains that transport it from the mine to the power plant, and most of those rail lines were built on land the federal government granted to the rail companies. And oil and gas get sent through pipelines produced through the power of eminent domain and financed through master limited partnerships, particularly advantageous financial structure. Now, the value of these special provisions is nearly impossible to quantify, and they're not represented on this chart, but certainly worth mentioning. And again, I'm not saying the federal government should not have provided these incentives. I'm just saying that anyone critiquing the federal incentives for renewables are operating under a false belief, really, that renewables are unique in this manner and being unfairly subsidized. In actuality, the federal government has been subsidizing all forms of energy for decades. It just so happens that the subsidies for renewable energy are more easily identifiable and easier to understand. Next slide. So let's look at those tax incentives for renewables, starting with the production tax credit, or PTC. For most of its life, the PTC was the federal tax incentive for wind. Unlike the investment tax credit, which we'll get into in a bit, and which is based on the value of the investment, the PTC is valued based on the amount of electricity a system produces over its first 10 years of operation. Now, most wind farms in the US will feed all their electricity directly into the grid and are paid either by other market players if they're in a competitive deregulated market, or if they're in a regulated market, they'll have to work out a power purchase agreement with their local utility. And in all these cases, the owner of the wind farm will earn their money on a cent per kilowatt hour basis or cent per megawatt hour basis. In a regulated market, the agreement you have with your utility should spell out what that rate is, and it could fluctuate over time. But in a deregulated market, the price is most likely determined more or less in real time and can fluctuate greatly. Sometimes if there is a peak demand, the price can peak in response. But then other times when there's an oversupply of electricity, the price can go way down low, such as the life of a plant operator. But the PTC gives you a bit of a hedge on all this volatility. You know the market price will go up and down, but regardless of what happens with the market, you'll always have this tax credit as a second revenue stream. The value of the credit started at 1.5 cents per kilowatt hour, but is adjusted annually for inflation and currently sits at a base level of 2.75 cents per kilowatt hour for wind systems that meet certain criteria. Next slide. So the PTC was originally enacted by the Energy Policy Act of 1992 and took effect in 1993, but it included an expiration date. Now, not to continue harping on the fossil fuel incentives, but none of those were built with expiration dates. It's not like the federal government tore up all the railroads on public lands after a few years, or rescinded all master limited partnerships for pipelines. Now, those are permanent incentives, but I digress. So the PTC was built with an expiration date, and in July of 1999, just as wind was starting to take off, it expired. Eventually, Congress changed its mind and decided to renew the PTC, but by that time, half a year had gone by and the wind industry was badly damaged. And then 2 years later, it expired again. This time it was dead for 3 months before being reinstated retroactively, only to expire again, this time for 10 months. Now, as we'll see in a bit, this unreliability had a major impact on the wind industry during this time, as well as other times, which we'll get to in a minute. But it's worth pointing out that financial incentives are supposed to incentivize behavior, not necessarily reward behavior. And any wind project that went forward during one of these periods where the credit was not available, they did so without knowing for certain that they would receive that tax credit. Now, I don't know how any of these companies, who any of these companies were, or what their calculations were like. Maybe they had assurances that the PTC would eventually be renewed, or maybe they made a high stakes gamble, or maybe the project would somehow pencil out without the PTC. But Congress, by allowing the credits to expire, did run the risk of rewarding behavior that might have happened without the tax credit. Good tax policy, in my opinion, should directly lead to the intended behaviors Congress deems to be in the public interest and for which they are targeting with tax policy. Otherwise, what is any of this for? So some more years passed and the PTC was renewed a few more times, but again, only for short periods. It still wasn't something that the wind industry could firmly count on being around while it continued to grow. Next slide. And then in 2009, as part of Obama's American Recovery and Reinvestment Act, Congress made some significant changes to improve its usability. And it also extended its expiration date for the longest time period since it was originally enacted. As you may recall, early 2009 was right in the thick of the Great Recession. Major financial institutions had failed, and others were left badly damaged. Now, another rabbit hole we could go down with tax credits is how they are monetized. We won't go down that rabbit hole, but we'll take just a quick little peek. So a wind developer might not have enough of a tax appetite to take advantage of the tax credit. So a big part of putting together a wind project is finding a tax equity investor. That's some entity that owes a lot of taxes, and they will own the project for a period of time until all the tax benefits have been extracted from the project, and then they sell it off. Well, in 2009, so many businesses lost so much money, most of these tax equity investors did not owe any taxes. So suddenly these projects were incredibly difficult to finance. The same situation was playing out with the investment tax credit, which is the main incentive for solar projects. And so Congress came up with a temporary provision that allowed the investment tax credit to be paid out in cash rather than as a tax credit. The Treasury Department would literally cut checks and send this money directly to project owners. Now, given the nature of the investment tax credit, the Treasury Department knew upfront how much the tax credit was worth. But the actual value of the PTC depends on how much electricity a system produces over a 10-year period, which is unknowable when a project is first built. So it wouldn't be so simple for Treasury to pay grants in lieu of the PTC. So what Congress did was to allow the technologies that were traditionally only eligible for the PTC to claim the ITC in lieu of the PTC. And then from there, they could opt for the cash grant in lieu of the ITC. So for a period of time, wind projects were able to receive a cash grant worth 30% of the system's cost. But then, of course, Congress fell back to its old ways and allowed the PTC to expire again. Though it was only expired for 2 days by the time Congress renewed it, the situation was a bit darker for wind based on 3 words in the tax code: placed in service. Now, for its entire existence, the expiration date of the PTC was based on when a system was placed in service. There's a lot of complicated guidance on what exactly that entails, but in essence, it means all the wind turbines are up and running and feeding electricity onto the grid. Now, a modern wind farm is a huge undertaking that could take well more than a year to complete. So even if a project commenced construction a year before the credit expires, there's a very good chance it won't be placed in service before the tax credit expires. So that's a huge amount of risk that this older and wiser wind industry. While a lot of wind was placed in service in 2012, it was all from projects that commenced construction in 2010 and 2011. In 2012, by contrast, activity dried up pretty much everywhere. There was just too much uncertainty. So when Congress renewed the PTC in 2013, they made a simple change with a big impact. They changed the expiration date from placed on service to construction commenced. So now the wind industry had a bit more certainty. Whatever happened to the PTC in the future, they knew that as long as they started working in 2013, their credit was locked in. And of course, Congress swiftly dropped the ball again, this time leaving the PTC expired for close to a year before eventually reinstating it retroactively. But that commenced construction change did a lot to keep the industry from a major downturn. Next slide. And then Congress made another major reform to both the ITC and the PTC in 2015. It extended the PTC for wind by 5 years. Other PTC technologies, I guess they didn't bring all their lobbyists to the table and they got a shorter extension. But as part of this long-term extension, Congress also introduced a phase out to the PTC, the ITC too, by the way. So projects commencing construction in 2015 or 2016 would receive the full value of the PTC. But projects started in 2017 would receive just 80% of the value of the ITC for the next 10 years. And then for projects that commence construction in 2018, they'd receive just 60% of the value of the ITC, and then 40% for projects started in 2019. And then after that, there'd be no more PTC. But we know Congress by now. They reset the clock in 2019, reinstating the PTC for 2020 with just a 40% reduction. Next slide. And Congress extended it again in 2020 before making the biggest changes yet with the Inflation Reduction Act, which Bryn will cover next. Next slide. So here's a chart, which I did not put together either, but it shows the impact of Congress's indecision on wind development over time. So you can see when Congress let the PTC expire in 1999, it really shook the industry and installations dramatically fell off in 2000. Things picked up again in 2001, but then dropped off again when it expired at the end of the year, and we saw limited development in 2002. But then Congress renewed it in March of 2002, and again, given development timelines, we saw the numbers pick up again in 2003, only to fall again in 2004 after it expired yet again. But then we had a few years in which it didn't expire and the industry got used to the rhythm of Congress's action, and the industry grew pretty steadily. But you can see the impact of the Great Recession. It took Treasury a while to get the grant in lieu of tax credit program up and running. And again, you have delays due to project timelines. So we didn't see a full recovery of the wind industry until 2012, when, of course, Congress let it expire again. But this was also when Congress changed the expiration to commenced construction. So we didn't see a complete collapse in numbers like we had in previous years. It just took a little while for the project pipeline to start moving again. Next slide. So that's the PTC. We'll now look at the ITC. As I mentioned, this is one of the this one is based on the actual system cost, and for most of its history and for most technologies, it's been worth 30% of the system's cost. Next slide. And this one goes back further than the PTC and initially included wind. Originally enacted in 1978, it was worth 10% of the system's cost for solar and wind technologies. And interestingly, it was refundable, meaning if the credit is worth more than the taxes you owed, Treasury would cut you a check for the difference. And it was renewed in 1980 and made more valuable. But when Congress renewed it in 1986, they made wind ineligible for it. Next slide. And so for several years, until the PTC was created in 1992, there was no federal tax incentive for wind. All the while, Congress was adjusting and renewing the ITC, sometimes allowing it to briefly expire, other times hitting a buzzer beater and renewing it just before it expired. But during this long stretch of time, wind was ineligible until 2009, when small wind, that systems up to 100 kilowatts, were made eligible for the credit. Next slide. And then, as previously mentioned, the American Recovery and Reinvestment Act allowed large wind to pick and choose between the ITC and PTC. And then more bills, all of which also impacted the PTC, as I've already mentioned. Congress introduced the phase out for the ITC, which also included a phase out for wind projects that chose the ITC in lieu of the PTC. It was also during this time that the solar industry looked at the commenced construction language that wind had fought for in the PTC, and they had the same language added to the ITC. Next slide. A couple more bills messed around with the phase out, trying to prolong the availability of this tax credit for wind and solar. Next slide. And then we flash forward to 2022. Next slide. And we have the passage of the Inflation Reduction Act, which again, Bryn will dive into in a minute. But to close out the theme of my time here, I'll just point out that for the ITC and the PTC, the extension made by the IRA represents the longest stretch of availability since the beginning of these credits. People have been talking about the IRA extending the credits through 2035, but in actuality, this is the earliest they could go away, absent some other act from Congress. The IRA actually tied the expiration date for these credits to the US reaching certain fairly aggressive greenhouse gas reduction goals, or 2035, whichever comes last. So there's a very real chance that these credits could actually outlive all of us. And then here's one last slide that I find helpful in visualizing which of these credits a project should consider. Since wind and solar and soon all clean energy technologies will be able to choose between the PTC and the ITC. Since the PTC pays based on production, the higher the capacity factor of a system, that is, the amount of electricity a system generally produces relative to its highest potential output, the more likely it is that the PTC will be the best choice for it. Whereas the ITC would be more advantageous for more expensive systems, since it's based on a percentage of the system's cost. But which of these is right for any given project? Well, that's something that project developers will have to pencil out based on the actual facts of their case. Next slide. And that's it for me. Thank you. And I'll hand it over to Bryn.
Great. Thank you, Brian. So really, what is the Inflation Reduction Act? I know we've kind of had a lead into all of the ITC and PTC history up to this point, but at the most basic level, IRA is a bill passed in August of 2022 to 1, address inflation, 2, invest in domestic energy generation, and 3, reduce carbon emissions in the United States. With the bill investing $369 billion, it's the single largest investment in climate and energy in American history, and allocates funds really through a variety of mechanisms such as tax credits, loans, and grants. Next slide. So, however, this presentation is really going to be focusing on the ITC and the PTC and their clean electricity counterparts that start to take effect in 2025. Under IRA, both the PTC and the ITC were extended for wind energy projects under construction before 2025. For the PTC, wind energy projects were placed into service between December 31st, 2021 and January 1st, 2025, receive an inflation-adjusted credit for 10 years. So for a project placed into service, the base PTC rate is 3 cents per kilowatt hour times that inflation adjustment. And if it meets the PWA requirements or the prevailing wage and apprenticeship requirements, the full PTC base rate is then at 1.5 cents per kilowatt hour times that inflation adjustment. For the ITC, the IRA sets the ITC at 6% as that base rate. And then again, depending on if it meets the prevailing wage and apprenticeship requirements, gets increased to that 30% tax credit base. In 2025, the PTC and the ITC become admissions-based technology neutral credits and really act very similarly to the ITC and PTC that I was talking about on the previous slide in terms of the amount and how it's structured. And again, are very contingent upon the prevailing wage and apprenticeship requirements being met. And these credits will begin to be gradually phased out in 2032, or when the total greenhouse gas emissions in the power sector decline to at least 75% below 2022 levels, or again, whichever comes later. So at this point, you might be thinking, Bryn, wow, a 6% credit is a lot less than a 30% tax credit, especially on these big capital intensive projects. To which I will reply, you are very right. And what's really driving that increase is what we've been referring to as that prevailing wage and apprenticeship multiplier, or PWA multiplier. So here's kind of a chart of what we've talked about so far. There's the ITC and the PTC and their clean electricity counterparts on the top. And then all of the base rates can be impacted by that 5 times multiplier if the prevailing wage and apprenticeship requirements are met. So what are the prevailing wage and apprenticeship requirements? In addition to the 3 priorities listed earlier, so 1, to address inflation, 2, invest in domestic energy generation, and 3, reduce carbon emissions in the United States, IRA aims to create and sustain good paying jobs in the renewable energy sector, as well as support some of this essential workforce development activities. And the PWA requirements are one of the tools to do just that. The PWA requirements really have these 2 prongs, which is the prevailing wage provision and then the apprenticeship provision. And if you're looking to claim the ITC or the PTC and have that 5-time multiplier, then you would have to meet both the requirements within the prevailing wage provision as well as within the apprenticeship provision to get that. So who does the IRA PWA really impact? And the IRA PWA impacts any taxpayers, contractors, or subcontractors who hires laborers and mechanics that will work on the construction, alteration, or repair of a qualified facility. In this case, the qualified facility would be the wind energy farm. The qualified facility, according to the finalized guidance, could also include some secondary sites if they meet certain eligibility requirements. The term taxpayer means an applicable entity that will generally claim the tax credit on their federal income tax return. And then the contractor and subcontractor typically are hired to support the construction, alteration, or repair of the project. So before jumping into really what this prevailing wage is in terms of IRA, I think it's important to provide some historical context. So prevailing wage has historically been mentioned in terms of the Davis-Bacon and related acts and utilized for federally funded or assisting construction projects. The Davis-Bacon Act was first enacted in 1931. However, over the past 90 or so years, many additional laws have been enacted to apply the Davis-Bacon labor standards, and those are resulting in the related acts. It is important to note that the IRA PWA is not the same as the Davis-Bacon related acts. The final regulations only incorporate DBA guidance if it's relevant for the purpose of the tax credit and necessary and consistent with tax administration. Due to IRA being a tax code and not a labor standard, factors like record keeping, reporting, and penalties differ from the traditional processes under DBRA. However, for the purpose of this provision, the definitions of construction, alteration, and repair and site of work, in addition to how you go about locating the most recently determined prevailing wage, remain in accordance with the Davis-Bacon related acts. In regards to IRA, the prevailing wage requirements are being leveraged to encourage fair and family sustaining pay and attract workers into the renewable energy industry. Any laborers and mechanics employed by the taxpayer, contractor, or subcontractor for the construction, alteration, or repair of the facility are paid at least the prevailing wage rate for that activity done in the locality of that facility. So wages can be a combination of basic hourly rate and fringe benefits, think healthcare. They are specific to labor classifications, type of work, and geographic location. And they are determined using periodic surveys, meaning that they can change depending on the time. Wage rates are determined at the time the contract for the construction, alteration, or repair is executed by the taxpayer and the contractor, and then therefore is applied into the subcontractors as well. And then in absence of a contract, the applicable wage rate would be one that's determined in effect of when that construction actually commences. So for 48E, which is going to be that tech neutral ITC, prevailing wage has to be paid starting at the beginning of construction and continues until the qualified facility is placed in service or that tax credit is claimed. And then for 45Y, which is the tech neutral PTC, prevailing wage has to be paid during the construction of the facility or any portion of a taxable year in which the construction, alteration, or repair occurs and is within that 10-year period beginning on the date that the qualified facility was placed in service. So through the construction through to that 10-year recapture period. As I mentioned, prevailing wage is also determined by geographic location. So for land-based wind, in an area which the facilities, it would be determined based on the area which the facility is being constructed. For offshore wind, it's really the geographic area that's closest to where the facility is being constructed. So moving on to the next prong, which is this apprenticeship requirement. Before jumping into the apprenticeship provision themselves, I wanted to make sure to define what a qualified apprentice is. A qualified apprentice is someone who is actively registered in a registered apprenticeship program, or as I will refer to them as a RAP. A RAP is an approved program by the U.S. Department of Labor Office of Apprenticeships or a state apprenticeship agency. And a registered apprenticeship program offers nationally recognized credentials, which allows individuals to really get that hands-on, paid, earn while you learn work experience. RAPs allow for more employers to participate in the training of the workforce and provides them with kind of a larger pool of individuals that have been trained for entry-level positions all the way through to management roles. Therefore, helping to meet industry demand, reducing unemployment rate, and promoting diversity, equity, inclusion efforts across the country. And although many RAPs are union affiliated, they do not have to be union affiliated. So looking specifically at IRA PWA, unless you're able to claim some sort of an exemption, which there are exemptions that I'm not going to get fully into this presentation, the apprenticeship provision in the IRA has three major requirements, which are the labor hour requirements, the ratio requirements, and the participation requirements. The labor hour requirements state that 15%, or as of 2024 or after, 15% of the total labor hours performed have to be from a qualified apprentice. The ratio requirements says that the applicable ratio to apprentices to journey workers has to be established, which is established by the RAP, has to be met. And then the participation requirements really saying that if a taxpayer employs 4 or more laborers or mechanics, they must hire at least one qualified apprentice. And that's to make sure that there's kind of diverse variety of the occupations that are served by apprentices. It's also important to note that there are correction payments and penalties if the PWA requirements are claimed but not actually met. They vary in amount based on if it's deemed to be intentional or unintentional disregard. So as a taxpayer, that means you have to have really good record keeping and maintaining of preserving those records throughout the 5 years of ITC, or around 5 years. And then the PTC is from construction through to that 10-year period. So in terms of the tax credit structure, we've gone over the ITC and the PTC and their clean electricity counterparts. We've talked about what the prevailing wage and apprenticeship multiplier is, as well as how it impacts that base credit and presents that 5-time multiplier. And then there's also these energy community bonus credits and domestic content bonus credit, which we'll be getting into in the coming slides. So I like to think of this as almost a sandwich structure where the base credit would be kind of that like meat. The 2 pieces of bread are the bonus credits. And then what enhances that sandwich would be that prevailing wage and apprenticeship multiplier. So in addition to the PWA multiplier, projects can receive these stackable bonus credits if they're located in an energy community and then meet a domestic content bonus credit requirement as well. So those domestic content thresholds. And then for projects that are less than 5 megawatts AC, they're looking to claim the ITC. They can also potentially qualify for these low income community credits, which is either a 10% credit or a 20% credit, depending on what category that it qualifies for. But I won't be going too much deeper into the low income community credits, and I will be mainly focusing on the energy community and domestic content thresholds in the coming slides. So one purpose of IRA is to support just transitions to the renewable energy that is equitably invested in and creates opportunities for communities and workers. So diving deeper into the Energy Community Bonus Credit, for the Energy Community Bonus Credit, it has to be an energy community and has a qualified facility that meets the requirements of being located or placed within an energy community. And this is defined as either being a brownfield site, a coal community, or having a statistical area that meets certain unemployment and tax revenue rates. So as you can see here, brownfield sites are kind of defined as these small portions of pollution contaminated land. They're designated by the US EPA or state governments for cleanup. A coal community would be considered a census tract or an adjoining census tract in which a coal mine has closed after 1999, or in which a coal-fired electric generating unit has been retired after 2009. And then for this jobs and tax revenue, it's a statistical area, so metropolitan or non-metropolitan statistical area that has either certain level of direct employment or tax revenue attributed to the extraction, processing, transport, or storage of coal, oil, or natural gas, and also has an unemployment rate higher than the national average. The unemployment rate does get measured on an annual basis. And so this, particular criteria can change year by year. So it's important to know if you are in an energy community when construction starts. So where are energy communities? The Department of Energy and the National Energy Technology Laboratory, as well as some other institutions, have created mapping tools that can be used to identify energy communities and allow you to play around with different layers to really see where they're at. The map uses green to show the census tracts that are considered a coal facility, or a coal facility with a closure and an adjoining tract. And then the pink shows the statistical areas that meet the unemployment rate and the direct fossil fuel employment thresholds. So every geographic unit you see here that's either colored in green or pink is considered an energy community as of June of this year. So also note that brownfield sites are not shown on this map. So in the second DOE map, it includes the ability to see brownfield sites when you overlay them. And so again, brownfield sites are typically smaller parcels of land, but you can see that they do have a good amount of dispersity across the nation. So while land-based wind can be sited in the highlighted communities on the previous map, offshore wind varies a little bit because it's not considered to be on land. So to claim the bonus credit, offshore wind energy projects can attribute their nameplate capacity to their onshore power conditioning and transfer equipment, or certain port facilities, depending on where that equipment or facility is located, and if it's considered an energy community or an energy community project port. So IRA aims to invest in and expand US manufacturing for the clean energy industry as well. So jumping into this domestic content bonus credit, which is the second of those two that I was talking about previously. And so IRA provides an additional up to 10% credit if it's the ITC, and then 10% credit if it's PTC to taxpayers that build their projects using 100% domestic steel and iron, and certain percentage of manufactured projects or products that were mined, produced, or manufactured in the United States. So as you can see here, land-based wind has that 40% domestic manufactured components, offshore wind is at 20% domestic manufactured components, and then those ramp up to 55% by 2027 if you're looking to claim the PTC for land-based wind energy, and then 55% by 2028 if you're looking to claim the PTC for offshore wind energy. So on the bottom is what we've gone over so far with the ITC, PTC, their clean electricity counterparts, prevailing wage and the apprenticeship multiplier, and how it impacts the base credit, energy community bonus credits, and the domestic content bonus credit. There are two additional tax credits that impact manufacturing, and it's the advanced manufacturing production tax credit, or 45X, and then the advanced manufacturing investment tax credit, which is 45 or 48C. And it is important to note that 48C is impacted by PWA requirements as well. So jumping into the advanced manufacturing production tax credit, which is 45X. 45X is not competitive, meaning that the tax credit can be claimed by any taxpayer who produces and sells qualifying products. The program provides benefits or full benefits through tax year 2029, and then partial benefits through tax year 2032. And so while this sounds pretty straightforward, There has been stepped up enforcements in recent years in terms of to prevent fraudulent claims. So you have to make sure to have proper record keeping and due diligence prior to claiming the credits. Wind energy components extend to nacelles, towers, both fixed and floating offshore wind turbine platforms, distributed wind inverters, critical minerals, and then offshore wind energy vessels. And they are calculated based off of the different production volumes of eligible components within a tax year, and then employing 3 primary methods, which is the value per component, size or weight, value per electric capacity, and then this percentage of production costs. So you can kind of see through this chart on the right. And then there's the 48C Advanced Manufacturing Investment Tax Credit. And so IRA reestablishes the Advanced Manufacturing ITC, and it can have a competitive award of up to like a 30% ITC. And so the IRA provides $10 billion to be competitively awarded for these projects, with at least $4 billion awarded in investments in energy communities. They just had their second round of applications recently, and so you do have to apply in, which is what it means to have a competitively awarded ITC. And with that being said, you also cannot, back onto the next slide. You can't stack 48C and 45X credits together, so you can only claim one or the other. And then with that being said, next slide. I am not a tax lawyer, so this can only be used as presentation of information. It's not tax advice. And so moving forward, if you do have a lot of follow-on questions, I suggest looking at or relying on tax and legal and accounting advice from a tax lawyer or a consultant or a accounting consultant. And with that, I'll hand it back off to Matilda.
Awesome. Thank you so much, Brendan, Brian. I learned so much through that, and I really appreciate your presentations. We will move on to the Q&A now, and people have been pretty light on the questions, so we'll have to do some of mine as well, but luckily I have lots. So I'll start with the first one in here. As the US is taking intentional steps to reduce its greenhouse gas impact as part of global efforts, given the precedent of the fossil fuel industry to have incentives in perpetuity compared to the sort of erratic treatment of incentives for wind, phasing in and out, has there been any discussion or traction at the congressional level to establish something more permanent that would more effectively align with US energy objectives? It seems counterproductive to maintain permanent incentives for some of the generation resources that the US is intentionally working to retire. Maybe I'll throw that one to Brian first, but Brendan, feel free to jump in as well.
Sure, and I think that's what Congress intends to do with the IRA. Where they tied the expiration date to the U.S. achieving a 75% reduction in greenhouse gas emissions, and then also having a specific date if we happen to hit that earlier. I think that is what Congress is trying to do to rather than just having an arbitrary date, tie it to these actual goals.
Maybe as a sort of follow-up to that, do you think there would ever be policy that would phase out the fossil fuel subsidies in the same way that these are maybe being phased out eventually?
I'm not sure.
I'll point this one at Bryn, since it's about workforce. Are apprenticeships merely encouraged or incentivized, or are they required for certain tax credits? So this is kind of a clarification question.
Yes, they are not mandatory to have apprenticeships, but if you're looking to claim that multiplier for the IRA PWA, then you do have to utilize registered apprenticeship programs or qualified apprentices from registered apprenticeship programs. So I hope that answered your question.
Now this next one, I think I can help to answer as well, which I'm surprised by. I did not think there'd be any I'd be able to help with, but if it's about what I think it is, what about remanufactured wind turbines where rebuilding is entirely in the US? Does that qualify for extra credit? And I assume that that's talking about repowering wind projects, which does allow project owners to re-up the production tax credit for another 10 years. That isn't in fact what analysts think is driving a lot of the repowering of projects that is being done, because wind projects in the land-based wind projects in the US are being repowered at an average of 10 or 11 years of age, which is obviously much younger than their components can last, which is more like 25 years. So if you repower a certain percentage of the parts, then you can re-up that production tax credit for another 10 years. Hopefully that is what that question was intending. Let's see. The question about similar presentation on other technologies impacted by the ITC. Unfortunately, because this is funded by DOE's Wind Exchange Initiative, and we that put it on at NREL are on the wind energy team, do not have any other insights into other webinars that are maybe being planned for related to other technologies, but I hope that those do get made at some point. I know that the Solar Energy Technologies Office at DOE has made similar webinars for solar, at least. So
I'll add a plug for Desire here that you can use Desire to find incentives for ground source heat pumps or other technologies, including the federal tax incentives. We don't have presentations per se about them, but we do have extensive summaries of them and links to the relevant legislation.
Awesome. Okay, I'll throw this one to Bryn as well. Is the current understanding that the number of available apprentices to work on projects would meet the labor demand from prospective project developers? If not, would be great to hear about the programs and incentives being created to stand up more apprenticeship programs.
Yeah, so I think that the current understanding is that there is a robust registered apprenticeship system going on within the US. I think it's really dependent on where the project is located, on if there is an available number of apprentices for that specific project. That being said, I will make a plug that in the coming months, we will be releasing some resources on the IRA PWA, and one of those resources is how to create or how to join a registered apprenticeship program. So I would definitely be on the lookout for that as well.
I see that there was a follow-up clarification about the remanufacturing that I was wrong. It referred to use of used wind turbines in a second life in distributed energy applications. That is a very interesting question that I think might have to fall under our Q&A after the fact, because I don't have any answer to that unless Brian or Bryn, you do. But we do have a lot of folks that work on distributed energy at distributed wind at NREL, so I will track some of them down for an answer to that. Would you say that the inclusion of the energy communities bonus credit implies that Congress assumes that wind projects are undoubtedly a net benefit for local communities? This is a really interesting question. My job is mostly wind energy, stakeholder engagement, and social science, so I will take a first stab at this one. I think that generally that is the correct interpretation, that it is implying that Congress assumes that not just wind, but any renewable generation technology that's included in that part of the PTC, or that part of IRA, I mean, would be a net benefit for local communities. Obviously, it is up to communities themselves and other people to make that determination for themselves about whether they think it is a net benefit. I think one kind of interesting part of this that I have thought about a lot is what Bryn mentioned with the offshore wind ports being able to qualify for as energy communities. Obviously, ports can bring a lot of benefits, such as jobs and local economic development. They can also bring challenges related to air quality and traffic and other concerns like that, displacement of other jobs, things that are more negative. And so allowing that to qualify for an extra tax credit by citing that in a community that's already disadvantaged in certain ways could be perceived less positively. So that is one example, I think, of how it's very complicated, but I think that's a really great and interesting question. Is there a minimum size requirement for a distributed generation project to be eligible for IRA tax credits?
I'm not aware of a minimum size. I know that the apprenticeship requirements and the other labor requirements that starts for systems 1 megawatt or above. So that's the one area in which size comes into play in these tax credits.
Are you aware of when we can expect new rounds of guidance from the IRS on complying with ITC? For example, there was a round of proposed guidance released for comment in November 2023, but final guidance was pending. Could you please provide reference or a link on where we to find latest IRS guidance?
I don't know when we can expect new rounds of guidance from the IRS, but I can happily supply links on where to find information on what's been released so far.
Awesome. Thanks, Bryn. Current opposition to federal investment in wind and other renewables hinges on the desire for conservative government spending. Was this narrative present for historic and ongoing subsidies for fossil fuels? If not, might that be due to the less visible mechanisms of subsidizing versus the more visible methods currently being implemented for renewables?
Possibly. I don't know. You know, I was a teenager in the 90s, focused on other things. So I don't know exactly what the conversations were about these tax credits back then, apart from, you know, Congress just being unwilling to put something out there in perpetuity for these technologies.
And are these tax credits restricted to proven technologies, or can they apply to demonstration projects and pilots for newer innovations?
There are definitions of what is considered a qualified project or qualified facility. I am not 100% sure on exactly that question, but I can get back to you unless Brian or Matilda, you have more insight into that.
That's a good question. I don't know. I don't know either. I know at the residential level for solar water heating systems, the tax code specifically references that these systems must be certified by the SRCC, the Solar Rating and Certification Council. That's the only place I'm aware of in the tax code that has kind of a firm, you know, criteria laid out other than just a broad definition of uses electricity to produce heat or electricity or wind to produce electricity. There could be something further in the IRS guidance that I'm not aware of, but as far as the tax code goes, there's no firm requirements that I'm aware of.
This doesn't exactly answer that question, but obviously there's a lot of other funding in IRA or bill, the bipartisan infrastructure law, that's more aimed at scaling up newer technologies. So if the tax credits do in fact do not extend to them, there's funding and other mechanisms meant to support those new innovations. Let's see if we have run out of questions in the Q&A. We can go to one of mine, which was, so many people consider wind to be kind of a more mature technology and industry compared to other renewable industries at this point, like solar and battery storage, hydrogen, or offshore wind. So land-based wind versus offshore wind. In other words, there might be a kind of perception that it needs less incentives and policy-driven support at this point. And I'm curious if either of you think that that's being reflected in IRA or other tax policy right now, in terms of phasing out or other things.
Not in terms of IRA, you know, back in the 2000s and 2010s, you'd see some states incentivizing wind development, usually, you know, smaller scale wind. And most of those incentives have dried up, but they've also dried up at the state level for solar for the most part.
Kind of a follow-up to that with offshore wind, it seems that from my outside perspective as someone who does not know tax policy, it seems like IRA has more kind of provisions built in for offshore wind than previous policy did. And I'm curious what you think the impact of that will be for scaling up this new offshore wind industry with its, you know, supply chain and inflation related challenges.
Well, at least just in terms of how kind of energy communities adopted in energy port communities later on, based off of kind of the realization, I guess, that a lot of offshore wind facilities might not qualify for that energy community bonus credit. I would generally seem to agree that at least it's being incentivized in a way that's conscious of the fact that there are some of these really good bonus credits to incentivize the technology in general, but
this question for the ITC, do you know if the 1 megawatt rule applies to projects generally or to each ITC technology on the site? If a project had solar, wind, and geothermal, as a lot of hybrid power plants are being built now, would each be installed up to 1 megawatt each or collectively? And this might be one for the Q&A later on, it's a little specific.
Yeah, that one's tricky. I don't have a good answer for it.
We can look into it.
I'm sure there's probably IRS guidance out there to better define that, but I don't know offhand.
If you have a BESS, and I actually don't know what that means. but-
Battery energy storage system, I think.
Awesome, thank you. Co-located next to a wind project in which the wind project is expected to meet the domestic content credit, the batteries will not. Can you claim the domestic content on the wind only portion? That feels maybe in the same bucket as the previous question, but I'll throw it out there because we have time.
I don't know. Bryn?
I would say that we will have to wait until the written Q&A to answer that one with like a sure statement.
And then the last one we have in here for now, does the direct pay provision enable foreign-based entities to leverage these tax credits without having themselves be a US-based taxpaying entity?
I'm honestly not sure on that one either. I have not looked personally into how the direct pay works in terms of foreign-based entities, but Brian, do you have any insight into that?
I don't know. I think that's another written response we'll have to get back with.
So we have maybe time for one more. If folks don't have one, I had a workforce one queued up for Bryn. As a workforce researcher, how do you view the IRA PWA, sorry, in terms of its impact on growing a trained and diverse workforce? Do you think that follow up to that the tax credits phasing out eventually could be an issue for workforce development?
Well, this is just speaking for me personally. I think that the IRA PWA does a great job of being a tool that helps to incentivize good training programs as well as family supporting wages and good wages. In terms of like eventually phasing out, I guess that's to find out in time to see. I don't have any analysis to back it up, but I do think it's an exciting tool to be following right now.
So it looks, that was the end of my questions, and I think that maybe the end of the questions in the chat. But I will just remind everyone, even if we answered your question live, we'll at least write down the transcript of that so that you can have that in writing, including the one that just came in right now. And thank you all for your excellent questions and for joining this webinar. Thank you to Brian Lips and Bryn McDowell for your excellent insights, expert insights into this. Thank you to the Department of Energy and especially the Wind Exchange Initiative for funding this ongoing webinar series. We will continue starting in February with another year of 3 more webinars on different topics in wind. We expect the next one to be about transmission and interconnection. And thank you to NREL, of course, as well for helping to put on this series. Thanks, everyone. Have a good rest of your Tuesday.
Thank you.